Good evening. This is Rahul Reddy. We are here live from REDDY NEUMANN PC every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Newman and Stephen Brown. Emily, what do we have today?
Yeah, so today we're going to be talking about HR 1044, the removal of the per country limit and where that stands in the Senate, what you can do to help support that legislation. We want to give you an update on H-4 EADs, long processing times that we're seeing, and what's going on with the lawsuits that we've been filing. We're going to talk about site visit issues. We've started hearing a lot of people saying that they had a site visit, and rather than talking about their current H-1B approval, the officers are talking about the first H-1B approval they ever got in the CAP from maybe 3 years ago. So what the trend is with that. We want to talk about traveling while you have an extension application pending, whether that's an H1 or H4 or L1, L2 application. What options do you have to travel while that's still pending? And we're also seeing some issues with things being brought up in requests for evidence, notice of intent to deny, or notice of intent to revoke that have to do with inconsistent information being given in different applications. So the PERM filing might give some employment history, and then the person has filled out a DS-160 visa application at the consulate that has slightly different information, and the government is saying there must be some sort of misrepresentation here. So what's happening, things to be aware of to avoid that kind of issue. So Stephen's here. He's going to be talking about what's going on with the lawsuits. He's kind of our team lead in terms of our litigation side of the firm. And of course, as usual, we'll answer your questions that come up during the show.
Emily, on the per country limit, we have noticed that it has been passed in the House 1044. It is in the Senate, a different version, Senate 3.386. What's the status of it? And, why is it, it's passed or is it not passed? Can you explain the legislative process? Can you also explain, what can people do to get this thing rolled out? What efforts they can do on this?
Mm-hmm. Yeah, so just because it passed in the House, it doesn't mean that it's law yet. So in our government, once the House passes a bill, the Senate has to also pass a bill. Now there is the Senate version of the bill. As of right now, there's one that's the same version as the House bill. If they were to pass that same version, then the bill could be signed into law by the president. However, if the Senate does all of its deliberations and compromises and comes up with a different version of the bill and passes that version, if it's different from the House, they're going to have to conference and come up with a compromise bill that both the House and the Senate agree to, and then that bill would have to be passed by the president, signed into law. So we still have a long way to go. We have to pass the Senate, we have to get it signed into law by the president. And as of right now, there are two versions of the bill. There's the original version that the House passed that was proposed by Senator Mike Lee of Utah, and that has been it's been on the books since January, February, but now Senator Rand Paul from Kentucky has introduced his own bill that actually would be even better because not only does it eliminate the per country cap, but it also raises the cap so that it actually eliminates the backlog for everyone. So that would be great if we could pass it, but we don't know which version they're going to move forward with in the Senate. And that's going to usually start in the committee process where they're going to do some hearings and markups and that sort of thing and come to an agreement. And then it'll be brought to the floor of the Senate for another round of debate and amendments and that sort of thing until a final bill gets passed. So we do have a long way to go. But what can you do right now? You can urge your senator to agree to this bill and be a co-sponsor on the bill and say yes to this bill once it finally comes through. And you can do that by calling your senator's office, by submitting letters or emails. Now, I don't have an updated sample on my blog, immigrationgirl.com. I will be putting that up there soon, but I do have one that I posted back in February. If you do a search on immigrationgirl.com for fairness for high-skilled immigrants, you should find a sample letter that I made that was both for the Senate and the House, and instructions for how to submit that to your senator. If you want to get started on that now, or you can wait, probably next week I might have a new sample for you posted on Immigration Girl.
One thing about this Senate bill that you're telling to write letter assembly, I've noticed that people just copy and paste it, put all the fill in the blanks and write it. They don't describe very much of their situation. I am advising those people who are stuck in this long line of this bill to write a detailed letter. Don't just say fill in the blanks. I'm waiting for 10 years, please give me the green card. Explain the situation, what you contribute to the society. Explain the situation of your family, how hard it is for you to move from one job to a job, how hard it is for every time you want to travel outside the country. Now you have to go to speak with an immigration lawyer, check everything is okay, and then you have to go and test yourself out in the consulate to get the stamping and count. And let's say, for example, if your kids are becoming 21, maybe your kids need to write a letter too. I mean, you need to have all these things. Remember that. This is the closest we ever got it. We got good support from the House. Good, about 80% of them supported this bill. We have a 35 co-sponsors in the Senate out of the 100, and that means doesn't mean that the rest of the people are not supporting. We have come very closer. This will make a difference. Your effort will make a difference. I want you, if you're going to be affected by this bill and you want this bill to be passed, please write a detailed letter. Explain your situation. What is your position? How long you've been in this country? What's your family? Did you buy a property in that particular state where you're living in? Work on. Give them all the details. If necessary, make an appointment with the senator's office. Go and visit them. And if any of the kids are becoming 21, have them write letters. Have them go to meet the senators. It makes a lot of difference when you go and meet the senators as compared to these kids meeting the senators. This is going to make a difference. Either it's going to be 150 years for you to get the green card or 3 to 5 years for you to get the green card will depend on this single bill. So practically 150 years, I'm not expecting that you're going to live that long, at least, hopefully maybe will you, but if you file an application right now, it's 150 years, and this bill might cut down the waiting time to 3 to 5 years. So please take this very seriously. If you are affected by this bill, please contact the senator. Now, when you are speaking with a senator, when you're speaking with the press, when you're speaking with anybody, this bill does not put Indians ahead of anybody else. This bill does not put Chinese ahead of anybody else. All this bill is doing is that it is eliminating the discrimination that is caused based on the country of birth. You're not asking to favor Indians. You're not asking to favor Chinese. All you're asking is to have a playing field. You don't want any preference. You just want to be a common person to get it. You don't want any preference. So when you're talking, there will be a lot of opposition that will tell to you that, well, this is favoring Indians. No, this bill is not favoring Indians. That will be your talking point. Now, coming to the main discussion that we have, this Stephen Brown, he's a business partner, and he's also head of the litigation in our office. Stephen, H4 EAD, that used to be an easy task. We used to attach the H4 EAD, H4 plus EAD with the premium processing of the H1B, and we used to get the approval. You already know that, and you've done a lot of those things by yourself. Now, what has changed to have the H4 not approved with the H1B? What has changed for the EAD not have been approved along with the H1B now?
Yeah, actually, it's one of the questions we're proposing to the court is not a lot has actually changed. Now, when USCIS introduced the biometrics that they introduced with the H4, they noted that some of these cases that used to be approved together in premium processing would no longer be done together because it takes about 17 days to get biometrics done, and premium processing is 15 days. So they said, look, we might see some delay, but we're going to try to expedite those cases because we understand people need these, that they're filing them together. That's not been the case. In fact, I think we're still waiting on seeing much of this being expedited or even being processed in a timely manner from our firm.
So what are the steps that you're taking? They're not approving it. Did you try to expedite the case? Did you contact the congressman? What did you try before you go for the litigation?
Yeah, absolutely. We've gone through traditional methods of expediting cases, filing expedite requests with USCIS saying that this is a severe financial interest, that this gets approved, that they're going to suffer a financial burden. USCIS is responding saying it's a normal processing. People are going to their local congressperson, and that used to be a very good avenue. Once Congress got involved, USCIS used to take steps to immediately rectify the problem. And now, USCIS is even telling them, hey, it's a normal processing, and we're not going to help out on that. We're not going to.
So what's the solution?
Yeah, so the solution is to file a delay lawsuit against USCIS, and what we're doing is through the Administrative Procedures Act, also known as the APA. We're taking that which requires the government to process these in a timely and convenient manner, and focusing on the fact that there's a line of court cases which gives us factors that courts should look at if a delay by the agency is unreasonable. And in this case, what we look at is that in the Immigration and Nationality Act, Congress has given their intent that all non-immigrant visas be processed in 30 days. And anybody that's done anything with immigration that hasn't paid for premium processing knows they haven't followed that in a long time. So what we're doing is we're focusing on the fact that Congress has given their intent. They used to approve these cases together. They don't take a long time to adjudicate, based off of what USCIS has posted out there in terms of what it actually takes, 10, 15, 12 minutes to do these cases. And then there's no reason for these delays. The government cannot justify the delay, and the delay is hurting people financially. It's hurting people with their insurance, their ability to drive, and so on and so forth. There's so many harms to the delay of these cases in something that's traditionally been approved with the H-1B. So that's the issue we're running into. Even though USCIS said they were going to try to do them in an expedited manner, they're not. And so we're taking actions in the federal court.
So you said you have taken actions in the federal court.
Correct.
How many cases that you filed, how many cases got approved? What is the timeline for it, typically though?
Right, so our first lawsuit we filed was, I think 35 days ago is when the lawsuit was filed and served to the government. At this time, we've got 75% approvals. We're waiting on that last 25% to get done, and that's still getting pretty good because the other cases that we're tracking that are around the same timeline are not getting approved through USCIS. So we are showing that it's working with the 75%. We're just getting a little bit more from a timeline perspective. The government gets 60 days to respond once the lawsuit is filed and served. And like I said, that first lawsuit, we're still only at day 35 today, so it's still a young lawsuit.
So you only filed one lawsuit, or
We filed two so far. The second one was just filed and served on the government last week, and we've actually already seen an approval in that second case as well.
So when you're filing the cases, do you file for each individual, so you group up the people to cut down the cost?
Yeah, so we group together to help reduce some of the costs involved. We'll run as many plaintiffs through as are wanting to get involved in these lawsuits.
Now, there's a lot of fear among the people in the society that if you file a litigation, they're going to come after you and shoot you. I don't know, whatever they are.
Yeah, I get the question a lot about what's the retaliation risk. It is people suing the government. The government's anti-immigration right now. We know that, and so people have that fear, and I can respect the fear. But what I can tell you is it's not something to worry about. One. The government can't get organized enough to retaliate against anybody. We've talked to people that have worked in the government as lawyers in the government, and they've told us the same thing. In fact, the government's more fearful of people who have sued them because they don't want to be sued again. And then number two, sometimes they're going to, like I said, they're going to take some chances to be more advantageous to you because you've sued them previously. They don't want to, again, be up in court. And if they do retaliate, that's another lawsuit against the government. I mean, that you have the right to sue. You're asking for something that you've paid for and that USCIS is bound by law to do, and you're just trying to enforce your rights. You're not asking for money. You're not doing anything extra. It's just we want what we should have, which is a timely adjudication, so you don't lose your job, lose your ability to drive, lose your insurance.
So what is the schedule for your lawsuit that you're going to file? If a client comes in, give me a timeline how it works out.
Yeah, so we can move pretty quickly on these. We're going to file one more on Friday. We've got that done. We're starting to finish drafting that one so that way it can get drafted. Our next lawsuit, if anybody wants to join, is going to be August 2nd. If you guys contact us, we can get you rolling pretty quickly on it. And the documentation you need is very, very minimal. It's receipt notices, approval notices, and just some basic information.
So the H1 must be approved.
Correct.
There must be H4 filed and EAD filed.
Correct.
And their fingerprint must have been done.
Correct, yeah. So what we're looking for is that the H-1B is approved and the H-4 and H-4 EAD have been pending for more than 30 days. And, it's not 30 days from fingerprinting. It's not 30 days from the H-1B approval. It's 30 days from the date you're filing.
Just for the people to be cautious that past results are not guarantee for the future results. I just want to let you know on that. And how do you split the cost for the people?
Yeah, I mean we're spreading it around to help reduce some of the court filing costs. So that way the more people we have involved, the less that we're able to absorb on our end.
Emily, on the site visits, now we used to have, we've been having site visits. The FDNS site visits went up by about 4 to 5 times, especially if the people are working for the consulting companies. What have you seen the difference right now as compared to like past 2-3 months as compared to previous?
Yeah, all of a sudden we heard one issue where a site visit happened and the officer was really asking questions not about their current employment, but asking a lot of questions about the original H-1B petition that was filed in the CAP. And this was not even the same employer that this person was working for. And we thought maybe it was just kind of a maybe strange issue for that particular officer. Or we didn't know what was going on, thought it was just that particular case. But all of a sudden, the last few weeks, we're hearing more and more situations where the officers are asking about the initial petition. And come to find out, they seem to be situations where the initial filing was filed as an in-house project, one of the in-house projects that we've been warning people not to do, with these duplicate filings where there really isn't work available, and then as soon as they get the approval, they turn around and place the person on a project at an end client and file an amendment, or the person turns around and transfers out to another employer. So it definitely seems that the government has figured out what this, loophole, if you want to call it that, is, where people are doing these duplicate filings and filing with a firm claiming they have some sort of in-house project. And although they approved them, now we're seeing more and more notices of intent to revoke those old applications filed 2 or 3 years ago.
So Emily, if they got the H-1B approval with company A, let's say in 2015 and 2016, they moved to company B, and maybe some of them have moved to company C. So this company A's H-1B is already expired. What loss would the individual have if they're going to revoke the H-1B that has been filed in 2014 or 15?
Yeah, this is the big issue that people need to be aware of, is if that initial petition is revoked due to fraud or misrepresentation, it's treated as if that petition never existed. It was never approved. That means you've never been counted in the CAP, and your current employer or any employer in between should have been subject to the CAP and also should have never been approved because they likely were not filed in the CAP. So ultimately, this could chase you to all of the future, or all of the petitions filed after that, to have each of those revoked because they were not filed in the CAP and it's a CAP subject petition. So that is a very big issue that's going to come around. So these notices of intent to revoke need to be treated very seriously.
I mean, one other topic is the travel. When the application, as Stephen is telling, the application delays is going on everywhere. We do have a congressional hearing today which addressed, and they were very mad, especially 2 of the congressmen from Houston were very mad on the delays that are causing in the non-immigrant visa application. And among other problems people have is that they have to travel to their home country, or they have to travel on the business, or they have to travel. What are the problems when the extension of the application is pending, or when a non-immigrant visa application is pending for a change of status? What are the problems people face in traveling? What should they be careful about, and what is the solution for this?
Yeah, so the first thing to be aware of, if you have a change of status pending and you leave the country while the change of status is pending, that change of status request is automatically abandoned. So if it, for example, is an H-4 where you've requested a change of status to H-4 and you leave while it's pending, the whole H-4 gets denied. not just the change of status portion, but the whole application, the I-539 is denied. If it were an H-1 petition or an L-1, for example, an I-129, where you filed a change of status request, the change of status will be abandoned when you leave, but the petition itself can still be approved. Once you have that approval, you can apply for the visa stamp and come back in to still take advantage of that approved petition. But extensions is a different story. If you have an extension pending, but your current approval period has not yet expired and you have a valid visa stamp that hasn't expired, you can actually go out and come back in while your extension is pending, and then once your extension is approved, that will be your new approval period. It will be extended beyond your current approval. The difficulty with that is, you always have an I-94 number. And so right now, the last I-94 number you got was probably when you entered the country. If you filed an extension since then, your extension is going to be approved with the exact same I-94 number. You keep that number with every filing until you travel again. When you come back in, you're going to be given a new number. So the idea of traveling while an extension is pending creates a problem with your I-94 number, because you filed your extension when you had this number, and your extension is going to be approved with that number, but in between you went out and came back in and got a new number. So it creates a mismatch between your numbers, and it's not so much an issue for your status, but it can create headaches when you try to renew your driver's license, if you ever have to submit E-Verify if you're starting a new employer, or if you need to visit Social Security office for some reason. They all use this SAVE database where they match up I-94 information with petitions, and so that's where you're likely to face an issue, and you may have to travel one more time to clear that up. So that's just something to be aware of. Now, one other thing for traveling when an extension is pending, once your I-94 has expired, you can't come back in based on the pending extension. So this only works if your current petition or I-94 has not yet expired and you're going out and coming in based on the previous approval. But if you go out and your I-94 expires, you cannot come back in again until you get the extension approved and get the new visa stamp to come in.
Emily, on the issue of the inconsistencies of multiple filings of the DS-160, I want to explain the audiences what is a DS-160. Is that this is a form that you fill in when you apply for the visa. Say for example, if you're coming on a student visa, if you're coming on a H-1B visa or any other visa, that's a form you fill it online and then you submit to the consulate, where the consulate will give an appointment, and then based on that they will grant you the visa for you to enter into this country. Now, Emily, you said that on this DS-160, if there is a inconsistencies, that means that if the job experience, for example, if the job experience that they have given before they came on a student visa is contradicting at a later time, that might create problem. Can you explain more why it has become more important right now as compared to previously?
Yeah, this really comes up, we're noticing in the I-140 process where, in order to file the I-140 in EB2 or EB3, you first need a PERM approval in most situations. And so that PERM process lists all of your prior experience, job titles, dates of employment, employer names, and your actual job duties. And when you're filing for EB2 or EB3, you always have to prove that you have the amount of experience that's required based on what it says on your labor certification. And so you're using your former experience to qualify for the position that you've been sponsored for. That's what allows you to get an approved I-140. But when you then go and apply for your visa at the consulate and you're filling out that DS-160, you also list your job experience history there. And we're finding a lot of people are, not concerned about keeping everything consistent, and they're putting different job titles there, listing different duties, sometimes not even the same dates are listed. When the government is then looking at the I-140 and they're looking at the PERM, which is signed under penalty of perjury by the individual employee who it's filed on behalf of, and you're looking at the DS-160, which is submitted at the consulate, and the job details don't match, they're saying, hey, maybe there's a misrepresentation or some fraud going on here. So it's very important that everything across every application you're submitting from one H-1B to the next. From, a lot of people have multiple perms filed. Each perm application should be consistent, and also newly the DS-160 needs to be consistent. So whatever's mentioned in your H-1B should be the same as what's on your DS-160. Whatever's on your perm should be on your DS-160. Everything should be matching and should be accurate.
Ankita has this question on the Senate bill. Is it good to send letters to the senators who listen, or is it good to send to the senators who I am residing at? Don't keep on sending to the senators who listen to you, because anyway, they most probably are sponsors, so you need to target the senators that where you're residing at, and probably target the senators who are not listening to you, who are on the opposite of it. I would request you for sure, even if your senator is listening or if your senator is not listening, try to contact the two senators at your state. If he is listening, say thanks for support for the bill. If he is not listening, then you try to explain your situation more detail. Now try to explain the situation for both the people. If the senator is supporting, you want him to support harder. If the senator is not supporting, you still want that guy to be on your side. Don't try to leave any of those things. Make sure that you send letters, detailed letters, and if necessary, make an appointment and go meet with them. And when you meet with the family, take your daughter, take your son, take your spouse and go and meet them. That would be a better thing for you to do. Contact your local senators for sure. Now, the other question is that if the Senate passes this bill, how long does it take for this to pass the bill? This is a question for Mishra. It is expected that President Trump is not vehemently opposed to this bill. At this point of time, he has not expressed. This bill is actually not increasing the number of green cards. It's just taking the discrimination off. We are not expecting President Trump to veto this bill. We're expecting him to sign this bill. That's what it stands for. Stephen, I have this question. Madam has this question. He filed H-1B and H-1B got denied for the extension. His I-94 is still valid until August 6, 2019. Can he refile the extension along with the H-4?
I would. I mean, I think you can, because you have a valid H-4. You can look into valid I-94 with the H-1. You can look into some options on refiling the petition, and there's a lot of arguments you can make to try to ask USCIS to make sure they approve it.
Did you see any approvals from the Nebraska Service Center? We have been waiting for a H-4 plus EAD approval. We've been waiting for 4 months. What's the thought on the litigation?
Yeah, I mean, I think what I've been telling people is action is better than inaction. We have seen approvals from Nebraska and California, and I believe Vermont as well. We've gotten all 3 service centers where we've gotten movement through the litigation. Once we file the litigation, it kind of lights a fire under USCIS to want to adjudicate these cases, because they really, in my opinion, don't want to fight this lawsuit. It's not a fight they want to pick. It's not government resources they want to spend when all they're talking about is delay. So filing the lawsuit really has that cause and effect. It's of trying to get that adjudication a lot quicker.
Maheshwar from Facebook has a question that comes up quite a bit. A situation of filing a change of status from H-1B to H-4, and then what happens if you get a new job offer and want to switch back to H-1B, but your H-4 is still pending, because as we've been talking about, H-4 processing times are taking forever. So when you've filed the change of status from H-1 to H-4, and you've stopped working for your first H-1 employer, you're no longer in H-1 status, but you're not yet in H-4 status because the application is still pending. You're in what's called a period of authorized stay. From there, to file a change of status back to H-1B, you have to prove that you're maintaining your current status, which again, you're not in status yet, you're in a period of authorized stay. So you can't change status back from H-1 to H-4 back to H-1B without ever getting the H-4 approved. The H-1B would likely have to be filed for consular processing. Once it's approved, you go out, get the H-1B visa stamp, and come back, and then you can start work again.
I have this question for you, Stephen. My H-1B got picked up in Los Angeles, and now I have another job that is within the same MSA. The H-1B is not approved. What are the risks for the H-1B approval. I got an RFE right now.
Yeah, so once you've got the RFE, I assume a lot of the questions are about the work that you're performing in the RFE. And unfortunately, you're in a situation where now you've changed projects, whether that first project ended or you're going to a new one. We used to have success going back to 2016 and early 2017 where we would file amendments, but really since the Trump administration took over, they're not approving these cases. Either they're going to look at any number of denials that I've seen, either one, that the project that you filed for no longer exists, so there's no reason to approve the case, or the new project that you're on didn't exist at the time of filing, and so we're going to deny it then. So unfortunately, we see a lot of denials when these projects end.
So is it the same situation if it's a different MSA and within the same MSA?
I think it's the same situation when you change the client. Now, if you change, if you're working at Pepsi in Houston and you go work at another Pepsi office in Houston, I think you can have some success with that. You just argue, your work address changed, but it's got to be within the same MSA. But when you change the MSA or you change clients, I think it's when it gets tricky with USCIS.
Question for you, Emily, from Nitin from YouTube. What is the exact date on which 1044 bill is going to come for hearing in Senate?
I don't think we have a date yet, and it really depends on what happens in the Judiciary Committee. So it's going to be up to the individual committee to get that on their calendar for their first kind of round of markup. And as far as I know, there's no date yet. I do know that kind of the plan with the bill is they want it to take effect from October 1st. So hopefully we will see something between now and October 1st.
In the meantime, don't forget to the things what we said earlier in the part of this video to contact the congressmen and senators, guys.
Question on Facebook from Divya. H-4 EAD is expiring in August. They already applied for the renewal back in April. What's the current processing time at the Vermont Service Center? Because it's already been 3.5 months. So currently, and I'm assuming that it was just the EAD that was filed for. So that processing time is 2 to 5 months at the Vermont Service Center. So you may be able to get that in time, but it really depends on if you've also filed the H-4 along with it, which is typical that everyone files the H-1, H-4, and H-4 EAD renewals all together. In that situation, it's based on the I-539 processing time, which those are anywhere from 2 months to 15 months, depending on which service center yours is at. I don't have Vermont on the top of my head, but certainly it is a lot longer than the 2 to 5 months of just the EAD.
Emily, this question is for you and me, and probably Stephen can pitch in too. What are the probabilities? Because as a client, if I were a client and I'm hanging here for a decade, and probably it will take 10 decades for me to get a green card. Simple question. What are the percentage of chances that this 1044 bill is going to go through Senate? Your opinion.
Yeah, so we talked about this a little bit last week. I may be a little bit more of a pessimist. I'm going to say 10% chance of it going through.
I'm going to say 20% because I think so that overwhelming support in the Congress, that means House of Representatives, might have an effect on the Senate. Now, don't be fooled by Senator Rand Paul's bill that he's going to double the entire green card application because employment basically, it may sound very good, but it's more distraction of the HR 1044 bill. If he wants, let him pass this bill and sign this one up and then fight for the doubling of the numbers rather than actually sidelining the 1044 and then putting out a bill on his own. I would rather prefer him to go with the 1044, and then once this is passed and gets the law, he can fight for getting a doubling of the cards. What do you say?
I'm unfortunately more of a pessimist like Emily. I think, it's going to be difficult to even get it to the floor. It's got to go through committee. We see some people that aren't, this isn't a political issue for them, so they're not going to take it as strongly. I would like to see it passed 15%.
Split the difference. I have a question for you, Stephen. This is from Eswar on Facebook. He's currently on H-4, wants to pursue a master's, and he's got admission into the university. What is the best option to get F1 status? Do you think that's a good idea to switch to F1 at this point?
It really depends on your goals. If your goal is just to go to school, you can continue doing that on H-4. if your goal is to go to school and eventually get on OPT and STEM OPT, in order to get those practical trainings that exist, you have to be on F1. So right now you can go to school on H4 and start that process to change your status to F1, so you can get the OPT and STEM OPT, and start that early because it takes about a year to get that change of status done.
I'm looking at this, Mr. Rashid from YouTube has this question. He has filed a 485 EAD and AP, and the lawyer is not giving access to the number of the 485 EAD and advance parole, and the employer is not giving the I-140. Your lawyer is under obligation to provide you the 485 receipt notices, EAD and advance parole. They belong to you. Your lawyer is not under obligation to provide you the I-140 approval of the employer. You can file FOIA, Freedom of Information Act, online, and you don't need a lawyer to file that. It's so simple form. USCIS, FOIA, Freedom of Information Act. You file it. It's taking about 30 to 60 days for you to get an I-140. So with regards to your lawyer, you need to contact him and tell him, hey, he needs to give it. That's yours. I mean, it doesn't belong to the employer, the 485 application.
Harini from Facebook has a question. The H-1 extension has been applied for and the I-94 is expired. Extension is still pending. Can I file a transfer now? So short answer is yes, you can, but the better question is, should I file a transfer now? And that's because your transfer is now going to be dependent on whether your extension gets approved because your I-94 is already expired. Once your I-94 is expired and you're staying based on the pending extension, you're in a period of authorized stay. You're not actually in H-1B status at that time. So when you're filing your transfer, you need to prove that you're in status. Again, that's not the same thing as being in a period of authorized stay. So in order for your transfer to be approved with the new I-94 card extending your stay, you're going to get a request for evidence asking for the extension approval. And if the extension gets withdrawn because you left that company, or there's an RFE and they decide not to respond to it because you're no longer there, it's going to get denied, and that's going to have a domino effect on your transfer. You're going to get that approval without an I-94, have to leave the country, take your risks at the consulate, getting the visa stamped, and if you get the visa stamp, come back in. So not really a great way to do a transfer.
Nagpal from YouTube has this question. Is it a good time to file a fresh H4 EAD? Yes, go ahead, file it. There's nothing there stopping you. Go ahead, file a H4 EAD. Another question for you, Stephen, that's coming from YouTube is that his H4 EAD, H4 plus EAD, is pending for 90 days. Is litigation the only option? Do you see any other options for it?
It's not the only option. It's, I think, the option that's working right now. So the expedite requests, they're not working. I mean, Emily, when was the last time you saw an expedite request actually get approved by USCIS?
I don't think I've seen one this year.
I mean, despite the fact that I've given some good facts, we had a duplicate card and all they needed was the card to be reproduced. The USCIS isn't expediting for anything. Like I said, Congress used to be a good avenue to go. They're not. I've gotten emails from people who have talked to Congress people, and they're not giving responses to the Congress either. So the litigation is a way that's actually working because the USCIS is not using traditional methods to expedite.
Karthik has this question for you, Emily, on the quota cases. His wife filed H4, is an H4 EAD, filed a H1B, not selected in the lottery, didn't receive the receipt notice. What are the probabilities for them to receive the receipt notice?
Yeah, unfortunately, if you didn't get a receipt by now, the petition was not selected. Unless something strange happened and a receipt was generated and it went to the wrong place, but you would know that because the company would see that the filing fee checks have been cashed. So assuming no filing fees were actually cashed, the petition was not selected, and you will be getting the return petition back soon, or the employer will. We've received about 18% of ours back in the mail that we're expecting so far. So those are coming now. RS asked this question. I need your attention, Emily, on this. His or her H-1B has been approved in 2007 to 2009, only used for 3 months. After that, the person has been continuing on H-4 visa. Can they file a change of status without subject to cap? Yes, absolutely. Even though it was that long ago, Once you were counted in the cap, you can recapture your time that you did not spend in H-1B status at any time in the future. So you could change status to H-1 and not go through the lottery. Now you're not going to get the full 6 years. They're going to subtract out the 3 months that you spent, but definitely.
Emily, in the same situation, I've heard that, not our office, but the other people telling that while it's been more than 6 years that the H-1B has been approved, or the H-1B validity period has expired in this case because it's 2017, can they still file the H-1B in this case?
Yeah, the January 17th, 2017 regulation clarified that, and it did confirm that there's no time limit on when you have to use that remainder option, and they actually changed the wording on the I-129 form to take into account that situation. So it used to ask, have you been counted within the past 6 years? It no longer has the within the past 6 years on there. So it's okay if your petition has expired, or if it's been more than 6 years, it's not relevant.
Question for the employment-based green card. What is the status of the employment-based green cards for Indian nationals? The backlog is between, depending on EB2 to EB3, starting from August. It's 2006 and 2009. In 2007, the priority date for EB3 used to be 2000. In 2007, the priority date used to be 2007. In 2019, 12 years later on, the priority date is 2006. So it's backlogged in 12 years by 1 year. That's a situation. So that's another need we need to contact the senators to make sure that the discrimination is taken off. We are not asking anything special status for the people who are in the backlog. All we are asking is to have a plain field things.
Russian from Facebook has a question. Next year is going to be his last chance at filing an H-1B in the lottery. STEM extension is expiring in May 2020. Wants to know when he has to leave the U.S., assuming the H-1 is not selected. So at the end of your OPT or STEM OPT, you have a 60-day grace period. So you would, depending on whatever the last date is mentioned on your OPT card, you have 60 days from that date to leave the U.S. It's not based on your I-94, because your I-94 likely has D/S for duration of status. There's no end date on the I-94. And your visa stamp is also not relevant. The visa stamp has nothing to do with how long you can stay in the country. It's based on 60 days from the date your STEM extension expires.
Emily, Deepak is asking this question from the YouTube, that he is an H-1B, but he has his I-140 approved. Can he be a partner in the startup with a U.S. citizen and continue working at the back door without a H-1B from that startup company?
Yeah, that's a really good question. We get that a lot. I think that immigrants tend to have a very entrepreneurial spirit and are always wanting to start businesses. And unfortunately, the H-1B only authorizes you to work for the company that sponsored your H-1B. So if you are, joining as a partner in a business and you're actually running the business or doing any work for that business, that's going to be considered unauthorized employment because you don't have an H-1B approval for that business. Now, that's different from passive investment, which is allowed. So you could invest money into a business and be basically a silent partner, not do anything related to the business and just take the income that you receive from that business. That's fine. But anything beyond that, where you're actually doing work for the business, you're running to the bank, you're signing paperwork, you're negotiating terms, you're dealing with employees, hiring, firing, all of that, none of that is authorized unless you have a valid H-1B for that business.
Question for you, Stephen, from Rohit from YouTube. He's asking the question. He has his H-1B approved. He initially came on F-1. His F-1 visa expired. His H-1 I-94 is valid until 2020. Can he travel to Mexico and stay there for 1 week and come back without H-1B stamping?
Yeah, so with automatic revalidation, you can do that as long as you've got your valid I-94 for your current H-1B. You've got and you travel for less than 30 days to Mexico or Canada, you should be able to do automatic revalidation.
Emily, can a H-1B person travel with the previous company's stamping to outside the country, not just Mexico, but outside the country, and he's no longer working for that company, he's working for company B, and company A's visa is still valid, but they withdrew the H-1B application. Can they travel outside the country with the H-1B approval with company B and come back into the country?
Yes, so that visa stamp, even though it's got the old employer's name on it, it is still valid until it expires. So you can use the old visa stamp with the old employer's name that hasn't expired and your new I-797 approval notice that has an I-94 on it to come back into the U.S. You have to be careful though, because sometimes the CBP officer will only give you the end date on your I-94 that matches the visa stamp, and that's not correct. They're supposed to give you the end date that matches your new I-797 approval notice. So before you walk away, check your passport stamp to make sure they gave you the correct end date that's with your new I-94. If they didn't, and you've already left, you may have to go to deferred inspection to get that cleared up. If you don't catch it in time, you could be considered to overstay, even though you had a valid approval notice. It's whatever the last action is, and so you need to make sure that they give you the right end date when you're entering that way.
Emily, this question continues on the non-immigrant visa people working. Is it possible for the H-4 EAD person to do day trading stocks with the spouse income?
Yeah, I don't see any issue with that at all. It doesn't matter whose income it is. If you're married and it's your income too. In the H-4
the other
holder
question:
can,
that do they need to have an EAD to do the day trading stocks?
in my mind, day trading is, even though you're not working for someone, I think you are actively doing a job because you're doing it so much. You're constantly doing that. So to me, that kind of crosses the line versus someone who puts their money in the stock market and leaves it there and gets dividends once a year from that money. That's okay. But if you're constantly working at buying and trading and buying and selling and buying and selling, trying to make a profit, that's kind of a business.
Yeah, it depends on how much trading you do. I mean, if you're going to do like 100 trades a day, that definitely looks like you're working. But if you're doing your 1 or 2 tradings a day, I may think differently, a little bit differently than Emily. But definitely, if you're doing 100 trades a day or 50 trades a day, I would think so. You're working.
Amit has a question from Facebook. Rahul, what's kind of the usual I-140 processing time right now?
It's between 6 to 8 months is a processing time for the I-140. You can do premium processing for the I-140 right now, and premium processing will get you in 3 weeks. And just a continuation of the, a lot of people have a presumption that the premium processing will get an RFE or denial. Do you believe in it?
Yeah, that's a huge rumor, and it's a really big myth. That's not true. We file a lot of applications in premium processing, and we file them in regular processing too. If it's going to get an RFE in premium, it would have gotten the same RFE in regular processing. But of course, you hear about it more because people just paid an extra $1,400 and get an RFE right away, whereas their friend continued in regular processing and they haven't gotten an RFE yet. Well, that's just because the government hasn't gotten around to it yet. It's not because they're not going to get one. So premium processing does not cause RFEs. It does not cause denials. There's a rumor that the more, knowledgeable or highly trained officers are the ones that handle the premium processing, so they're scrutinizing everything more and it's harder to get the case approved. I don't think any of that is true.
Just to clarify the H-4 EAD and the day trading thing that we discussed, Emily, and that what we said was that if the person has a H-4 EAD, they don't have a problem 100 trades or 200 trades. On the H-4 EAD, that's not a problem. If you don't have an EAD, that's when you need to discuss how many trades you're going to do. On the H-4 EAD, absolutely you can do 1,000 trades a day.
Stephen, Naveen has a question from Facebook. He wants to know, is it any different if I file just the H1 and H4 in premium processing and not the EAD? Do you get the H4 any faster that way?
No, in fact, I think what we've discussed with our team is that it's actually the H4 holding up a lot of the H4 EADs. The H4 EAD times, like Emily had mentioned earlier, are not that far off. It's waiting for the H4 as well. So the H4s, like I said, I think Vermont, when I last checked, it was 8 months. I think some of the other service centers are a little bit less than that. You're still going to be waiting for that H4 to get approved.
Yeah, and I think the new strategy some people are thinking of now is filing just the H-1B renewal super early in premium processing, getting it approved, sending the H-4 spouse outside the U.S., getting the H-4 stamped, coming back in, and then filing the EAD. Now, the EAD processing time is still longer than it used to be. You don't have that 90-day processing time anymore, but that may be faster. But again, then you're paying for the flight, you're dealing with the hassle of visa interviews and getting stuck there. So that's just another option for a slightly faster but more hassle factor.
Question for you, litigation guy, Stephen, is that have you seen any Nebraska H-4 EAD that has been filed on or after March 11th for the biometrics that got approval?
I don't think we have from our office.
No.
Through
For the
litigation?
litigation.
Through litigation, yes. Through non-litigation, I don't think we have.
Okay, and here is the case that I'm showing you.
Yeah, no, I do know I have one through litigation. I was,
And that was the first case that got approved in 13 days, actually.
Yeah, it was 13 days after we served the government.
But that doesn't mean that every time it takes 13 days, guys. Yes, the first case that got approved for our office through Stephen was actually Nebraska Service Center. So, I don't know why people think so that Nebraska is immune from the litigation. No, they're not. We know that Nebraska processing time is a long period of time. But yeah, Nebraska period, the first case that we got approved in the litigation that we filed in June 1st week actually was from Nebraska Service Center.
Bhuvana from Facebook has a question. Has an H-1B transfer pending that's in premium processing, got stuck with a request for evidence, and wants to know if the current employer can go ahead and file for an extension now. So assuming that the I-94 has not expired and you're still working for the current employer, you haven't joined the new employer yet, yes, there's no problem with that.
There was a question I saw on YouTube from Ravi. For H1 amendment and extension, does the 240-day rule apply? And I think when we've done some digging into the comments and the responses to the comments that USCIS and DHS put out, that it does not. It only applies for extensions with the same employer. I think
although initially we were expecting that the amendment plus extensions were actually the 240 days is applicable. But
Zach in our office did some more research into this recently and has determined that based off of the comments and the replies to those comments, that amendment plus extension does not apply to the 240-day rule.
Does not apply, so they can work even beyond 240 days.
That's correct.
When it's an extension and the amendment, but if it's only extension, they can only work for 240-day rule.
Kishore from Facebook has an interesting question. He wants to know, what is the grace period to join the new employer after an H-1B transfer has been approved? Technically, you never have to join the new employer. You can continue working for your existing employer. That new transfer H-1B becomes a dormant H-1B at that point because you've never actually used it and joined that employer. So from a status standpoint, again, there's not really a grace period. Your existing H-1B remains valid. 6 months from now, if you want to join the new employer and they haven't withdrawn, that dormant H-1B can be used still, and you can join 6 months in the future. However, there is an issue from the employer's side regarding the wage liability, because an employer, when they file an H-1B transfer, they're going to list an intended start date for you to join, and if you don't join and they don't start paying you within a certain period of time, they could be liable for back wages to you. But if it's your choice that you're not joining right away and they keep that documentation, then that's fine. But this isn't a situation where they filed a transfer, you stopped working for your old company, and they don't have work for you, so they told you not to join. Now that would be a problem. That's benching, that's illegal, they can't do that. But if it's your choice why you're not joining and the company is willing to wait for you, there's no problem in doing that.
Vaishali has this question from YouTube. She filed for the H-4 EAD. It's not approved yet. Can she apply the jobs, or is it illegal to apply the jobs? You can apply the jobs. Absolutely no problem. You can apply. You cannot work, but you can apply for the job when the H-4 EAD is pending. Also, to continue, when the H-4 EAD extension is pending, if it's not approved and your current EAD expires, you have to stop working. Here the question was, can she apply the job? Yes, absolutely, that's not a problem.
Muhammad from Facebook wants to know, how do you know that your H-1B was filed as a change of status versus consular processing? Is there any way to know? So you'd have to have a copy of the I-129 form, and it's going to be on, what is it, page 2 now? Page
Yeah,
1,
it's
page
page-
2?
yeah.
There's several boxes, and one box is for notify the consulate, and another box is for change the status. So you can't find out unless you actually have a copy of the I-129 form that was filed.
Stephen, I have this question from YouTube and from different questions. I'm merging into one question is that we have seen a lot of denials coming in the past 1-2 years compared to previously. Is motion to reconsider or appeal or the only option, or do you, and if those options are, what are the probabilities? What are the other suggestions that you will make if there are any?
Yeah, I mean, there are a ton of options. You have, obviously, when a case is denied, an MTR or an appeal. Those are traditional methods. The problem we've seen with the government is that they aren't traditionally working to approve those cases. I think the latest statistics show that the appeal process is about 3% approval rating after it gets to the Administrative Appeals Office. They're looking, talking with an attorney that used to work with the AAO. Their job is to play backstop to the service center and try to back up their opinion with better law. One of the better options, if your case is denied and it's really, the term of art here is arbitrary and capricious that we're looking for, is you can sue USCIS on a denial of your H-1B. Looking at the fact that the regulations are there, and a lot of these policy memos are outside of the regulation, and that's what you're suing on. They're going well beyond what's actually required. There's a lawsuit on whether these things are even required that's handling the whole policy, but you can sue on individual denials, and I think that based off of what we've seen, that has a better success rate than going through the appeals process.
The other things you may want to consider also actually very seriously is that sometimes refiling the H-1B is another issue. Sometimes filing a consular processing, even if you don't have an I-94, might be a thing that you need to consider. If your I-94 expired, you may want to argue a thing called non-protunct. Please excuse me for being out of status for the extraordinary circumstances, and you can apply another H-1B. You may want to consider those options too before going to motion to reconsider appeal. When we evaluate in our office, though, most of the time, we choose to actually go to the path of refiling the H-1B application, then actually ending up to motion to reconsider or filing the appeal. If you file to motion to reconsider, if your I-94 expired, you cannot work with that company. That's a problem. If you file an appeal, you cannot work with this company. And these are very time-consuming process. And sometimes your case might or might not be ripe for filing a litigation. So you may want to consider the options of refiling the H-1B, either in the consular processing or using the non-protunct argument. And sometimes, these things with the premium processing there right now, you will get a result much faster than the other options that you may have it.
Stephen, I have a question for you from Anand on Facebook. We talked about before when the biometrics came out, the idea of maybe we should file in regular processing and then upgrade after the biometrics have been done. Have we tried that? Have we seen anybody that got the approval that way?
So I personally haven't. A lot of my clients still want to file together, but I have seen other plaintiffs in our lawsuits that have done that option, or even came about before biometrics and their case was pending while biometric, once the regulation and the new process got put into place. And it's just not, I haven't seen anything work, filing premium after the fact, where they've responded to the H1 RFE, upgrade to premium at that time, and then the H4 and H4 EAD are still pending well after biometrics.
Question for you, Stephen, is that how long before the H4 EAD expiration? I mean, they file for extension. The H4 EAD is not expiring right now. How long before they can file the litigation?
Yeah, so the litigation, like I said, we're looking for the H1B being approved and 30 days after it's been filed. Not anything to do with the biometrics or anything. It's just we're looking for you filed
so even
the
if the
case 30 days
expiry,
ago.
even if the H4 EAD is still valid.
Absolutely, yeah. The earlier you can get to our office, the easier it is to get you a positive results. We can, because it does take time to go through the court process. But like I said, we're looking just to see that it's been filed. It doesn't matter if your EAD expires 160 days from now.
Anything you have, Emily, any announcements you have to make?
Yeah, so I wanted to let everyone know that our firm is hosting a webinar coming up soon that's going to be covering all the different options available for filing in the EB1 and EB2 categories. This is going to be hosted by Crystal Alanis and Amanda Cardwell. They're two of our attorneys in our perm practice. They file tons of labor certifications, but they're also very familiar with all the different I-140 options that are out there. So they're going to be hosting this on Thursday, August 8th from 1 to 2 o'clock. We have the link for you to register on our Facebook page today. So if you go to Reddy and Neumann PC on Facebook, you should find the link and you can register for that webinar today.
Thank you very much, guys. Thank you, Stephen, for coming in and for educating us on the H4 EAD litigation. Thank you, Emily.
Thanks for
Thank you.
joining.